Good morning and welcome to the first webinar in a series on technology contracts. I am Ann McDonald, Business Development Director at Morris Manning & Martin Law Firm. Thank you also to ATV for helping us host this event. MMM handles matters including mergers, acquisitions, venture capital deals, intellectual property, employment, and contracts, which is today's important topic. It's my pleasure this morning to introduce you to Matt Sanroman. Matt is a superstar in the MMM Tech Transactions practice group. Matt has worked with over 100 tech companies and has experience representing buy-side clients in due diligence. He negotiates and deals with issues every day that can affect the valuation of your company. Contracts may not sound like an exciting topic, but Matt will be giving you practical pointers today that will affect your company when you raise capital or have your big exit. It's my pleasure to bring you Matt Sanroman. And I also want to encourage you to ask questions in the chat feature, which I'll be checking during the presentation.
Great. Thanks, Ann. Good morning, everybody. And thank you to ATV for helping us put this on. Like Ann said, Matt Sanroman here to walk you through the first part of our webinar series, Negotiating Tech Contracts. Today, we're going to focus on limiting your exposure and how you can use your contracts to do that. Our next session in about 2 weeks, which is reflected on our next slide, will be about protecting your assets. My colleague Brian Gamsey will head that discussion. Our next session after that is about protecting your business. We'll focus on restrictive covenants. And my colleague Mary Claire will head that discussion. And then finally, the fourth part of our webinar series will be a fireside chat with a current MMM client, AssureSign, also an ATV villager, which will be an interesting discussion with their Chief Revenue Officer, Courtney Schickel. First, I want to touch on why, on the next slide, why contracts matter. Obviously, many of you will understand, so I won't spend too much time on these, but as Ann mentioned, many of you are likely interested in raising capital or some sort of liquidity event. So contracts matter for a whole bunch of reasons that we'll talk about throughout the webinar series, but always keep in mind that they matter a lot to people who might be investing in your company or buying your company, and they'll be looking at this with a very strict eye. As Ann also mentioned, a good chunk of my practice is representing buy-side clients. And so I spend a lot of time kicking the tires on various target companies, going through the contracts, and I do see our clients walk away over contract issues, especially ones that arose early in the life cycle of a particular target company, where they did something they didn't understand, in particular if it relates to a contingent liability out there that was extremely onerous, or intellectual property issue that calls into question the ownership of its IP assets. So always keep in mind that your potential investors and acquirers are going to be very keyed in on your contracting process. So hopefully today's discussion will help you tighten that down and make sure that that's not an issue in the future. On our next slide, we'll focus on some common contractual relationships. Today, most of what we'll talk about is your direct sales relationship with your customer. So you can assume that that's usually what I'm referring to, and I'll refer to, I'll try to make it from a provider perspective as well as a customer perspective, but keep in mind that these principles are applicable in other potential contractual arrangements, like with your indirect sales through strategic partners, distributors, VARs, OEMs, the like, that we do a lot of that work, as well as your suppliers, upstream providers, hosting services, and the like. And then our third session will actually focus on that fourth point: your contractor, your personnel, your contractors, and your employees, and how you can use restrictive covenants to protect your business. As I mentioned, the issues are a little bit different, but the principles will apply across them. as one more initial matter on our next slide, from a strategy perspective, one thing that can save you a lot of headache as you negotiate contracts, as you move through them with your counterparties, is make sure that you're starting with the right form. I often find that you'll have a SaaS provider, for example, that gets their customers one size fits all MSA, and it has things in there that won't apply for a SaaS. For example, I was representing a buy-side client, and we looked at some of their early agreements with customers, and they were MSAs that might look okay for a SaaS provider, but it had a bunch of work for hire provisions in there where it called into question whether or not the target company's IP had been assigned to that customer. Obviously, that wasn't anybody's intention. They just used a form that didn't make sense for their business. And so it does make sense to take a step back, look at the document that maybe you were provided, and is this the right form to use, or is there another form which can also save you any legal fees that you might incur through negotiating through red lines and back and forth, as well as delays. And also, we're mindful that many of our clients don't necessarily have the bargaining leverage, and they need the deal, they need the revenue. So at a minimum, at least understand what is in the contract if you don't have necessarily the leverage to force a different contract to be used. So with that, a quick rundown on the main substantive topics we'll talk about on the next slide. We'll focus on force majeure, limitation of liability, indemnity, warranties and disclaimers, data security, and data use. Those will be our 5 opportunities where you can use them to limit your exposure to your counterparty. On the next slide, force majeure. So I didn't initially have this slide as my first slide, but it's been such a hot topic recently. It's not a new concept. It's been around for a long time, force majeure. But it's been particularly relevant in the past year or so. As many people can imagine, maybe you've experienced already, that a lot of people are using the pandemic and related governmental actions as a force majeure, as something that was outside of their reasonable control. And therefore, that's an out for what otherwise might be a breach of contract. And it's a way to delay performance or excuse performance. So from a provider's perspective, that can be quite advantageous. You've got to make sure that the force majeure is appropriately scoped. So looking at your force majeure, make sure it's including pandemics, make sure it's including government actions. You, of course, want to have the catch-all, anything outside your reasonable control. And if you're going to use it, make sure that there often are notice requirements associated with them. So make sure you're complying with any notice requirements that are in them. And also keep in mind that many, if not most, force majeures require you to use some sort of effort level, reasonable efforts, best efforts to get around the impediment. Whatever it is, the force majeure event that's happening to mitigate your damages. And even if your force majeure doesn't have that specific language, you have a built-in implied duty to mitigate in any contract. So keep in mind that you have an obligation to try to get around. And sometimes that could be implementing your business continuity plan if you have one of those in place. From a customer's perspective, you want these to be narrow. You don't want the catch-all. You want a list of events. Ideally, you don't want to see pandemics in there. You don't want to see government actions in there. Obviously, providers want the opposite. Also, one other practice pointer for providers, make sure that it doesn't include payment obligations. You don't want to have a customer use the catch-all market forces. There's been a business downturn, things that were outside of my control, and now I don't have the money to pay you. So keep in mind that if you've got a force majeure, it doesn't apply to an obligation to be paid to you. On our next slide, we'll talk about indemnification, limitation on liability.
Matt, I think we had a quick question here from John Robinson relating to force majeure, but let me ask you this question. Is that something that people should begin looking at their indemnification clauses now, that in terms and conditions and in other agreements, should they be studying them to see if they're addressing these issues, or do most of them, do you think, already address pandemic and the like?
No, I think it's a great thing to review. Of course, review now, and I think really annually you should be looking at your terms and conditions to make sure that you are, when events like COVID-19 happen, you're contemplating those in your terms and conditions, and your force majeures are keeping track with what's the current events at the time. All right, it looks like taking a quick look at John Robinson's question. It depends. So John, is the BAA, are you the provider? Are you the business associate in that BAA, or are you the customer? Because if you're the business,
we're the provider.
Okay. If you're the provider, this is great. I think it's a little bit unusual. I don't typically see force majeures in a BAA, but if you're the provider, if you're the business associate and you have a force majeure like that, that's great. And that could be a really good shield for you in the event that something happens and you're not able to comply with your obligations under that BAA. I would say that I think that is a little bit unusual, but if you're not getting pushback from your customers, from the covered entity, then I'd say go with it.
Awesome. Thanks.
And Matt, one other quick question. Are you beginning to see in your diligence in connection with transactions where you're looking at agreements for companies that are that your clients buying, are you beginning to study and see more questioning about force majeure clauses? Are people beginning to look at them more carefully now?
Oh yeah, no, absolutely. That's certainly part of our diligence checklist, is to take a look at we don't necessarily look at every single executed contract, but we will look at the forms. Certainly depends on the scope of how many contracts there are, but we will look at all the forms and check the force majeure and make sure that there's adequate protections, especially if it's a provider contract. You want to see those in there. Certainly. Great question. Next slide. Limitation on liability. So I think three main concepts to keep in mind here. And this probably is your most important liability limiting mechanism in your contracts. So you've got three main sub concepts here: the damage cap, a damage disclaimer, and then exceptions. So all your contracts should have at least a cap. And this will be, if everything goes wrong, if the worst case scenario happens, this is your bottom line liability that you'll have to the counterparty, subject to any exceptions, of course. The damage disclaimer is a set of damages that are off the table that can't be recovered. They're outside of the cap. So things like consequential damages, indirect damages, punitive damages, those are all generally, and it's market to have those not be recoverable by either party, again, subject to exceptions. One example of a consequential damage is lost profits or lost business. If you're providing services to a customer and that customer relies on your services in order to run its business, or in order to provide its products or services to downstream customers, lost profits can be a huge metric if it's not disclaimed. So that's an important one to make sure that, loss of goodwill is another important one. Reputational harms. If you've got a large customer like a Google, or someone has a big brand, a lot of value in their brand, having goodwill, loss of goodwill, damage to reputations, those are all typically consequential damages. Having those off the table is an important concept. Thirdly, exceptions. Exclusions, there's typically exclusions. As a general rule of thumb, providers want low caps and few exclusions. Customers want high caps and many exclusions. That's because the provider has the obligation to actually give the product, give the service. It's got performance metrics and the like. So making sure that the caps are low makes sense for it. And the customer, of course, wants the opposite of that. Common exclusions, indemnification is very common. That's why it's very important. We'll talk about that concept next. Breach of confidentiality, gross negligence and willful misconduct. Those are all pretty common exceptions to see.
So Matt, a questions was asked here with respect to typical caps for liability. And in particular, if you're the provider, there are a lot of tech companies that are represented here in this webinar. And in the past, at least, sometimes the provider has tried to keep the cap low by saying it's some multiple of the amount of fees they receive, which obviously in a SaaS model could be fairly limited. What are you seeing now in negotiating for where you're the software company and you're trying to keep that cap low, but the customer says, look, you're not going to get away with one-time caps or something?
Right. Yeah, no, that's a great question. So a typical cap for a SaaS provider is based on the fees. You always want to have some proportionality between the risk and the reward, right? The risk and benefit analysis is important. So you will see very often a look back period, fees paid under the agreement, and then you want to see a time bound on that. So fees paid in the past 12 months is very common. That's what I usually suggest. Depends on the context a little bit. If it's a low dollar engagement, $1,000, $2,000, $5,000, sometimes you'll go like to 3 months look back or a 6 month look back in terms of the fees paid. But 12 months is pretty typical. Of course, customers, like I mentioned, want to expand that. It's not uncommon also because that time bound takes a while to build up. If you've got monthly payments, you might have a contract where there's been no money paid in the first month or very low dollars. So a lot of times you'll see customers introduce a concept called a floor. So that it'll be the greater of $500,000 or fees paid in the past 12 months. And that way that early on in the contract, the customer is getting a minimum liability cap that they'll feel comfortable. It's a new relationship perhaps, that they feel comfortable they can pursue their provider at least up to that $500,000 to use the example. There's a way that's not that uncommon to see it. I think that can be problematic for providers because it sets an arbitrary number. You don't know how much money you're going to be paid necessarily. They may not have an obligation to actually purchase. There may be no minimum amounts, and you may have a contract sitting out there where you're generating $5,000 a month and you've got a $500,000 cap, so it can feel kind of arbitrary. A middle ground there is to have an annualized number. So if it's less than 12 months, if that's our cap, then we can say an annualized version of the cap. So it's not arbitrary $500,000, but there is a relationship between the revenue and that floor amount that the customer asked for. Great question.
There's another question on insurance, but I think that we may need to keep going. But Deidre asked a good question about cyber breach insurance. We're going to cover that in a future session. But would you say also, Matt, it's important for companies to go ahead and talk to their carrier about the scope of cyber breach insurance and what might be covered in connection with these, liability in this area?
Yeah, no, cyber insurance is crucial today. I mean, everybody should really have that. If not for the cover, because they've got a bunch of their customers' data, but also for their own employees, if they have a significant amount of number of employees, it's worth protecting. But you see in terms of tying that into a liability cap, you do often see customers will ask that either you're uncapped from a cyber data breach perspective. That's a common exclusion you would see. And then also you'll see proposals as, well, maybe not uncapped, but the cap is your cyber liability insurance problem. I recommend my provider clients to push back on that for very good reason, which especially if you're a SaaS company, you're collecting lots of data from various customers. If you have a data breach, often that's outside your control, it's going to affect your business and all your customers generally. So having one customer have access to the full amount of your cyber liability policy doesn't make sense for you. And that they really should think of your insurance that you carry that you might be able to use for them as a supplement to their own insurance policies. So there's a little bit of risk sharing there with respect to data breaches, which often, again, like I said, you have sophisticated parties out there. It's hard to really for any provider to guarantee that that's not going to ever happen.
Robinson has included a good insurance clause, by the way, that people may want to look at. And one final question, I know we need to move on, but Jonathan Jacobs asked, will any liability cap for gross negligence, willful misconduct be enforceable?
Great question. Oftentimes they're not. It is state by state. And I haven't come across, I can't say that I've gone through every single state, but I have not come across a state that will let you cap those two things. So that's a funny one to get into a back and forth. You'll often have customers insist on that exclusion. I wouldn't fight it. It's not worth redlining and going back and forth on because it's not enforceable. Certainly not here in Georgia. Gross negligence and willful misconduct, you can't contract out of those. So you see that red line, accept it, move on. It's not worth fighting over. Our next slide, I think, is indemnification. Also a important concept. I think you can think of this, practice pointer here is just think of this as an obligation to pay. It's sort of an indemnification. It's kind of an old legal word, fancy lawyer term, but just think of it, replace it with obligation to pay, and it usually will make a little bit more sense. There are things to think about with indemnification. One, you want to make sure that the scope of the damages, the scope of what's being captured is reasonable. It's not all first-party losses or all first-party claims, meaning a claim between me, provider, and you, customer, but it's claims related to a third-party lawsuit. So something I have done to cause a third-party lawsuit is a much more reasonable scope. And in fact, most laws, unless it has, and you'll see the bolded language in the example to the right, unless it has something like any and all, a court will read it as a third party. But when you see that any and all, that will suggest that first party claims are part of the indemnification. So on the last slide, I mentioned indemnification is often not subject to the limitations on liability. If you have something like any and all first party claims are part of it, then you really don't have a limitation on liability because indemnification has been carved out and it now applies to all first party claims and first party losses, right? So always keep in mind that loophole. Breach of contract is another popular one. Do you have a limitation on liability for breach of contract? If it's so broad that it covers first party claims? Not really. So it's important to keep that in mind that you don't have a scope that's overly broad. You'll see the second set of bolded language in the example to the right. Any acts or omissions of provider. Well, what about acts or omissions of provider that the customer wanted you to do? The customer input into the contract as part of the negotiation to do A, B, C, and D. Should you have to indemnify them if you comply with what the customer wanted? Of course not. So, you've got to have some fault basis there, right? It's got to at least be breach of contract. You said you would do something, you didn't do it, and that's got to be a triggering mechanism. Although even that can get a little bit dicey with breach of contract, because like I said, indemnification can be, often is carved out in limitation on liability. I think the third thing to think about here with indemnification, and I understand I'm throwing a lot at you, so feel free to stop and ask questions here. The third thing to think about is procedure. If you're talking about a third party claim, say it's IP infringement. I'm the provider. I've promised to pay you for damages related to a third party claim of IP infringement. Well, I'm going to need to make sure as a procedural matter that I've got the right, that I know about the claim, right? You've gotten a letter from a third party that says you're using our technology, you're infringing, pay us, right? You forward the letter to us. We got to know about that first. Second, we need to control the litigation. So we need to be able to hire the attorneys, make sure it's not a New York firm at $1,000 an hour because I'm paying for it. I need to be able to pick the attorneys that I want to use and that I want to pay for, and then be able to control them in terms of when's the right time to settle. Again, given that you're the one that's paying the bills at the end of the day via this indemnification clause. And then finally, the other procedural matter is they need to work with you. The party that's being indemnified, if it's a customer, they need to provide reasonable assistance to you. Maybe that's just sending you the letter that was sent to you by the third party, sharing information with you that maybe you didn't have, right? So just a reasonable obligation to cooperate and work together. So I see some questions in here. Let me take a look at. In terms of a baseline for indemnities, it depends on what seat you're sitting in. So if I'm a provider, I want an IP infringement. That's basically market. You're not, almost in a technology context, you're not going to get away without having IP infringement indemnity. It's very market, but that's it. That if you could get that, if that's your form, that's all you want to have in there and leave it at that. you're going to see customers ask for things like breach of contract, violation of law, data breach, data security. Those are common ones to ask for, but keep in mind that indemnifications are often carved out of your limitation of liability. So it's important to come back if you're okay with those. And sometimes it is appropriate or fair to ask for those things. Come back over top of them and put another cap on top of them. In the data breach, what I see now with our clients is that that's very market. You'll have a regular cap like we just talked about, and then you'll have a secondary, higher extended cap for data breaches. That's very common to have that kind of a concept built in. For our next topic, we'll talk about, if you can go to the next slide here, is warranties and disclaimers. So these can take a lot of different flavors. It depends on your context. You can have hardware or on-prem software warranties that have time bounds on them, maybe 90 days or so for an on-prem software. And then, hardware could be a little bit longer, a year, up to 2 or 3 years. Just depends on the particular product. You just got to keep in mind what the financial implications and risks are and what you're promising here. And really that factors in, and where these can be beneficial is the remedies. And that's my practice pointer here is the 3 R's: repair, replace, refund. And that's what, from a performance warranty standpoint, what a customer, what's market, what a provider would want to see and be able to use those warranties and use the remedies to limit its exposure to a customer. So if you've got a SaaS product, you might warrant that it will conform substantially in accordance with its product documentation, specifications you might have provided. And if there's a problem, the customer will let you know about it. And then you'll have an obligation, you'll have a right or an obligation, however you want to think about it, to fix it or replace it with something that's just as good or that works just as well. Or at the end of the day, you might have a termination and a refund. But the idea here is to prevent lawsuits, to prevent something where you've got to have lawyers involved and they're exchanging and running up legal fees. Can get much more expensive, perhaps, depends on the context, than just providing a refund and making the customer whole. That's often acceptable for customers from a performance warranty standpoint. But of course, there are other warranties you might see, such as IP infringement warranties. You might see security warranties or virus warranties. From that perspective, a customer might ask you, we want a warranty, we're using your technology, we want a warranty that will not, no viruses will be introduced into our system. So it's a strict liability warranty. And that often, and if I'm representing the provider, I say nobody can promise that. Nobody can control the sophistication level of third-party actors. Oftentimes they're nation states with nation state funding, and nobody can guarantee that no viruses will ever be introduced. What we can guarantee, however, is our process. We can guarantee that we will comply with the security obligations in Exhibit B, where the InfoSec terms are. And so we'll implement and maintain those processes in a manner that's designed to prevent viruses. So you're not guaranteeing a result, but you are guaranteeing a process. And so you only have exposure to the extent that you didn't implement a process, which is something you can control if you're a provider, right? Of course, the customer wants the flat, strict liability. And in either case, if you're handling any significant amount of personal data, you should always cap these, come over the top of data breach or virus warranties and make sure that they're capped. Another common warranty you'll see, IP infringement. It's an understandable ask. You see it all the time, especially in customer forums. Keep in mind the interplay between an IP warranty, though, and an IP infringement indemnity. Through the indemnity, you're handling that third-party claim because you've got a third party who is saying you're infringing on my technology. So you're already handling that, and then oftentimes those are coupled with, the 3 R's that I talked about: the repair obligation, the replace obligation, or at the end of the day, if it's not possible to to get a license from the third party or fix the technology so it's not infringing, you might have to terminate their contract and provide a refund, which if you're talking about an indemnity perspective, that's actually going to cut off your damages, because each time the customer uses that infringing technology, that's running up your damage total to that third party. So you are going to want that ability to eventually terminate and provide a refund, and it would be a prorated refund for any time that hasn't. If we're in a SaaS context, a prorated refund for unused time left in the subscription term. If you're talking about hardware, it's usually on a 3-line or a 3-year or 5-year depreciation schedule. Obviously, 3-year would be preferable if you're a provider and you want the longer 5-year if you're a customer. But so if you're already providing those remedies under your indemnity, giving a customer a breach of contract claim for IP infringement on top of all that is too much to ask. It means that some subset of your customers are going to sue you for breach of contract in addition to your indemnity obligations, right? So that's usually the pushback there, is that we're already making you whole under the indemnity. You don't need the breach of contract claim.
Matt, we've got some good input by John Robinson, by the way, for everyone in the chat with regard to insurance and indemnification. Thank you, John. And there's also a question that relates to the notion of sort of the scope and negotiations of these clauses. To what extent, and maybe rephrasing that, to what extent is it valuable for folks that are here that are negotiating these kinds of agreements to have alternate and optional provisions? In other words, it's not a 0-1 game, but it's a situation where should the company have sort of alternate fallback positions with regard to these various issues so that they can negotiate through them rather than just saying no?
Oh yeah, no, absolutely. No, you always say yes. Here's the form of what I'm going to give you this concession, and here's the form of it, and you give a form that works better. So what we do with our CMS clients is we develop playbooks for our clients so that they have those fallback positions. They've got their form, their preferred language, and they have fallbacks language that they can use in the event that they're getting, if they have a customer ask for a virus warranty or a virus indemnity. Okay, maybe not that way of implementing that concept, but here's our fallback language that we use. So that's definitely something I recommend that you either do internally, and we can also help you put together those playbooks so that you know how you typically respond, and there's sort of a standardization across your contracts, and it's not addressing the issue new each time it comes out. Certainly. I
know one of the things that's been put in these playbooks too, for the benefit of the audience, is oftentimes you have your optional provisions, as Matt points out, but you may also have citations to certain cases. So if the other side says, look, everybody does this, then you may be able to point to a particular case. And we track a lot of these cases to say, well, look, not everybody does it, because if you look at these particular cases, the courts have held that these particular clauses are unenforceable, or that that's not the way they should be drafted. So that's usually a much more valuable negotiating point than just saying no. So good points, Matt. I know you got to move on, but this is a healthy discussion here.
Yeah, no, and I was looking at Benjamin's question. How do these change? How do these things change when you're talking about scale? They can change quite a bit. It depends on the amount of money. The bigger the contract, the bigger the opportunity, the more risk you might be willing to take on. Of course, you need to manage that via your liability caps. And if you're getting requests from customers, and you will, your big ones that are spending a lot of money, they're going to want that breach of contract indemnity, right? And so, the response to that is are you willing to take that risk in view of the opportunity that's in front of you? And maybe there are ways to mitigate it in the contract via a cap that comes on top of it. It's not uncommon to see multiple tiers of caps. Here, we'll give you the general cap, and we'll give you a second tier cap for breach of contract indemnity. That might be a way to solve that. And then insurance has been mentioned in the chat. That's another way. It's sort of outside the contract, obviously, but making sure you got insurance is an important risk mitigation tool, sir. Okay, our next slide. Data security. This is our fifth topic for this session. And this is really operational in nature. Obviously, with the explosion in SaaS services and hosting outsourcing, you're seeing a lot of focus on data security. And that's because you're hosting all the data for the customer, assuming you're the provider. Just a few quick stats for you guys. According to the most recent 2020 report from IBM and the Audemars Institute, the average cost to a company for a data breach is $3.86 million, which is a 10% increase over the last 5 years. And that number includes both direct and indirect costs and related to the time and effort in dealing with the data breach, lost opportunities such as like customer churn from the bad publicity, regulatory fines. You might have notification costs to affected individuals and state governments, credit monitoring costs. You probably will have to hire forensic experts to figure out what's happened. There's a number of costs that are rolled into this number. So it makes sense that from a contract standpoint, that you're not signing up to obligations that you can't comply with. And it's very common when you get a customer agreement or the counterparty's agreement that they've got data security provisions in there that are too expansive, that they don't comport with your operations, and maybe you're willing to change your operation on the basis of that deal. If it's a big enough deal and an important enough deal to you, then maybe you're willing to have a pen test every year and report the results. Maybe you're willing to do the SOC 2 audit testing. And we have clients that do that because the deal is important enough. From a customer's perspective, you want to make sure that you've got providers that are good stewards of your data, right? You've got a legal obligation to your employees, to your customers and their users, consumers perhaps, to safeguard those data. And that if the provider does something and there's a data breach there, you want to have an ability to recover from them, whether that's via a breach of the data security exhibit, often is its own standalone schedule, as well as through your indemnification provisions, affirmative obligations to reimburse for some of those items I just talked about, notification vendors, credit monitoring, perhaps a rehabilitation specialist, marketing experts, your attorney's fees. Those are all things you want to think about. Who ought to be paying for those expenses? If you're a provider, you want to limit that to fault-based. You don't want a strict liability obligation to be on the hook for those expenses. So it's got to be, if you're a provider, what I usually recommend is a breach of the InfoSec schedule that causes a data security, right? So there's a nexus between a breach of the agreement and the event and the data security event, right? And then again, like I mentioned earlier, you're going to want to come back over top of that and put a number on it and really try to avoid that number being your cyber liability insurance policy. It's very common to see that exception. But again, like I said, if you have a data breach, it's oftentimes company-wide, customer-wide, and you've got other customers you're going to have responsibilities to, and you can't necessarily offer everybody access to your insurance policy. Obviously, if you're a customer, you'd love for that to be uncapped, and you'd love for and you're probably okay with the insurance number too. Depends on how much records they have. I think the average cost per record is $146 per record in terms of a data breach. So there's a way to calculate it. You get with the internal team, how many of our records will they have, times it by the most recent number, and then we can put in a cap in there that makes sense. Or we can look at the provider's insurance policy that we're requiring them to carry and make sure that it's sufficient based on how many records we expect that they'll have. The next slide, please. So I think we talked about most of this stuff. The practice, so the third bullet point there, just touch on that real quick. Many of our technology clients need data for other reasons than just performing under the agreement, right? They use de-identified data, for example, to improve their products, build new products. Perhaps they have other business opportunities with this data. Make sure that the data rights that you're getting in your contracts are sufficient for what you're actually doing with the data, right? This is a common thing that we see in diligence. We know that we're targeting a company that has a AI-based technology, and we look at their customer agreements, and they've got no right to use the customer data to train their AI models, right? They haven't put that into their contract. And so that's a problem, both from a contract standpoint and perhaps also from a regulatory standpoint if it's personal information. So making sure that you've got adequate use rights in the customer data is an important one, and one that is increasingly becoming more common with our customers. It varies by industry. Healthcare is a tougher haul to convince healthcare hospitals that you should be able to use their blind data or anonymous or aggregated data. But I do have clients that are successful in doing that as long as they're complying with HIPAA regulations with respect to de-identifying and aggregating data. So the practice pointer here is make sure that the InfoSec operate from an operational perspective is something you can comply with. Oftentimes, your attorney isn't going to necessarily know that because they're not as familiar with your operations. I do have clients that I've represented them for a number of years now, and I understand, I see this enough that I know what they're doing and what they're not doing. But it does need to take a close look from a business angle, from an operational perspective.
So Matt, one of the questions has been asked here about data security. How do you comply with government obligations and limit disclosure in other places?
Great question. In your contract, so it depends on the industry, right? Healthcare is going to have different obligations from a regulatory standpoint than say a media industry where there's fewer regulations, right? And so we've got a very good privacy and security, cybersecurity team that we work with to make sure that not just from a contract standpoint, but also from an operational standpoint, that they're complying with their obligations. From a contract standpoint, you will see sort of breach notification requirements that are based on regulatory compliance. So, for example, in GDPR, which is the European data law that was enacted in 2018 in May, that law is sort of now being copycatted around the United States. We've got California's version of it, CCPA. They've got requirements in there to notify after 72 hours of becoming aware that you've had a data security breach. It's very common now for that to sort of flow through your contract. So you'll see that number, and really, if you get a customer form, you'll see 24 hours. And if you have an understanding of what the regulatory requirements are, you know where the number actually should be. It should be 72, not 24, right? And then it's different, of course, under HIPAA as well. So we work together with our privacy and cybersecurity team to make sure that the contracts that our clients are signing up for are not overly burdensome, and that they're compliant with the various regulatory scheme. And of course, outside of the contract, as I mentioned, we work with our clients to make sure their operations are consistent with the patchwork of privacy regulations in the United States.
So Matt, I think we're near the end of our session here. From a timing standpoint, great information. Maybe just if we go to the next slide, but also as we do that, maybe you can just highlight the couple areas that you feel like when you're working on behalf of a technology company, what you really need to make sure that they're focusing on as far as potential problems if they go to raise capital or later sell the company. Those seem to be the biggest issues that oftentimes people aren't thinking about, but become pivotal when a company wants to ultimately cash in. So what would you say to be the two or three biggest areas that companies need to make sure that they are really focusing on, that they don't trip up on and create problems in the future when they want to go sell the company or raise capital?
Okay, yeah, great question. And that is the goal of almost all of our technology clients, and one that we work through all the time. I'd say three areas. One, your liability exposure through your limitation on liability. So what's the cap look like, and what are the exceptions to it? Is an important one that we look at, we key in on. A second one is, do they have the right data use rights in their contracts? I just talked about that. It's important that we can look at the contracts and we'll know what kind of company is, and then do those two things align or is there a problem from a contract standpoint that's built out across all their customers, and also from a regulatory, so it could be a two-pronged issue on the data use rights. And then the third one that we see very frequently, and it's often a problem, is that you've got IP. We just spent a lot of time on that today. Well, my colleague, Brian Gamsey, will talk about that in the next section. But you'll see IP assignments in a SaaS context that has no business being in there, where now we're wondering whether or not the target company has ownership rights in its technology, or if it didn't assign those away to one of its customers because they didn't want to ask, or they didn't know what was in the contract, or they didn't understand that it might affect their technology as a whole. And whether or not you're able to fix that isn't always up to you. It's up to the customer, right? Is the customer going to agree to fix that problem later? I mean, maybe they didn't intend that they receive assignment to some or all the target company's technology, but are they willing to sign a document when you're trying to close a deal to assign it back? You just don't have a lot of control there. So making sure that problem's not built in from the very beginning is crucial.
Matt, thanks for the very valuable information. I want to thank John Robinson and all the folks who have added to the chat. There's some good information there, especially with regard to some clauses, some reference to insurance, reference to indemnification, a very practical information, Matt, that you've provided and your team. You might want to talk briefly about the March 9th session, which will be also at 10 o'clock, protecting your assets, licensing rights, ownership rights, and confidentiality. Matt, just give us a 1-minute preview of that session and what's going to be focused on there.
Yeah, so here we'll be focusing on how to use your contract to safeguard your intellectual property and perhaps other assets. So it will focus on what's the scope of the license, what should your license look like. You don't want to have a SaaS contract that has a perpetual license in it. You'd be surprised how often we see things like that, where you've got a customer, maybe you didn't assign ownership to them, but you gave them a forever license to your intellectual property, right? So what's the right scope of license, and how you can reserve ownership to your intellectual property rights will be the substantive topic of that discussion.
Great. Well, this has been a useful discussion for us. I'm glad to see that we've got great participation here, good comments back. We'll use this as an opportunity to continue to find other topics of interest, and we appreciate everyone's participation. Matt, thank you for a great presentation, and thank you for the introductory remarks. And if you have other comments that you'd like to share with Matt, Matt, how's the best way to reach you?
Yeah, if you'll go to the next slide, my contact information is there. Please reach out to me. If I didn't get to a question that you asked, or if you think of something later, please reach out to me. There's my email, my phone number. I'm happy to talk with you.
Thanks so much, everyone. Have a great day, and thanks for participating with us today. Matt, thanks.
Thanks, everyone.